Hi, my name is Michael Burgis, and I'm the managing attorney of MB&A. I'm also a legal certified specialist in California workers' compensation, and I'm a trial attorney. I wanted to do this video to educate the viewers of some recent case law that's come down, specifically the cases Atkinson versus First Transit. This came out in February 26th of 2019, a very recent case. This is going to be part one of a two-part video. The first part is I'm going to explain something called C.O.L.A, cost of living adjustment. I want to explain what this is and how it's applicable before I go into the holdings of this case. First off, C.O.L.A. C.O.L.A stands for cost of living adjustment. What this is basically how the court can take into consideration the ramifications of inflation. So before I do that, let me first explain this. An injured worker is entitled to compensation over time based on permanent disability. The greater the level of permanent disability, the greater the entitlement of benefits and the greater the amount of overall compensation is. Now, this compensation is not paid in a lump sum, it's paid over time. So the greater your disability is, the longer the duration of these payments. Now, if somebody is above 70% disability, when their permanent disability stops, they receive a small stipend, generally a little bit above $100, and it gradually goes up with something called cost of living adjustment. That means that amount of money is supposed to gradually go up to sort of counteract the inflation. Now, the earlier the start date of that permanent disability, the earlier the start date of that life pension. Now, the case law establishes that the injured worker is entitled to that cost of living adjustment at the start of when they receive that life pension or when the permanent disability stops being paid. Now, in a case 70% to 99%, that C.O.L.A starts to kick in when the life pension starts paying. And that could be years down the line depending on the severity of the permanent disability. For a 100% case, that kicks in from day one of the temporary or of the permanent disability payment, which is much earlier. Now, the earlier the start of the permanent disability payments, the earlier the start of the life pension case, and the earlier the C.O.L.A kicks in, the earlier the cost of living adjustment is taken into consideration, and it's compound. So the cost of living adjustment will gradually go up, up, and up. So for injured workers, we want the earliest start date of the life pension to kick in, which means we want the earliest start date of the permanent disability initial payments. Now, part two is as follows. The Atkinson case establishes that there was a dispute between an applicant and a defendant. Here's the fact pattern, because it's a bit complicated. An injured worker sustained two industrial injuries. The first industrial injury caused temporary disability benefits for a period of time. Those stopped. The applicant was found permanent and stationary, went back to work, and ultimately the parties adjudicated that that disability was 73% for that injury. Subsequent to that injury and the applicant going back to work, they sustained a second industrial injury, which caused a separate and distinct period of temporary disability, and then later a subsequent and distinct period of permanent disability. Now, the injured worker's attorney argued that the start of C.O.L.A should be earlier because the first date of injury, the start date of the permanent disability should have been the end date of that temporary disability. And the defendant argued, well, wait a minute, there was a subsequent injury that caused temporary disability and then later permanent disability. So the defendant argued that later date is the start date for permanent disability. Once again, the sole issue here was what was the earlier permanent and stationary date? When was the permanent disability supposed to be initiated? The earlier the date is, the earlier the C.O.L.A starts to kick in and the more advantageous it is for the injured worker. Now, frankly, I think the law is pretty clear here, and I'm surprised that the defendant even made these arguments because they're separate and distinct injuries. One doesn't have to do with, frankly, anything of the other one. And I believe the correct legal analysis is the first injury caused 73% disability and a period of temporary disability, and then the permanent disability started here. This theoretically has nothing to do with some subsequent industrial injury or subsequent temporary disability or subsequent additional permanent disability. The holding in this case, once again, Atkinson's versus First Transit, held as follows. The appropriate date for determination of the C.O.L.A, the cost of living adjustment, was in fact the earlier permanent and stationary date and the earlier initiation of permanent disability. Because once again, that date of injury and the start date of the permanent disability there had nothing to do with a subsequent industrial injury or a subsequent additional period of temporary disability or a subsequent additional amount of permanent disability attributed to that date of injury. So the Atkinson versus First Transient case, I think, is spot on. I think it's accurate. And I'm a little surprised that the defense attorney even made this argument because, frankly, I don't think there's any good justification for it. And, of course, the holding in this case confirmed that. Once again, very complicated case, very difficult legal analysis here. But to reiterate this, an injured worker is entitled to C.O.L.A, cost of living adjustment, if they're entitled to a disability award above 70% disability. Once again, if they're above 70 but below 99, that C.O.L.A kicks in from the first start of the life pension. The earlier date that the life pension kicks in, the sooner the cost of living adjustment kicks in, and the greater the overall compensation the injured worker is entitled to. So an injured worker wants to argue the earliest date there. This case holds that if there's a subsequent industrial injury and a subsequent period of temporary disability and or additional permanent disability, that does not defer the permanent and stationary date to a later date. The original date applies. Once again, on a 100% disability award, the start of C.O.L.A is on the day of permanent disability, not the life pension, because the permanent disability is the TTD rate for life. Viewers, very complicated stuff here. Ultimately, if you believe you're entitled to a disability rating above 70%, you absolutely should get an attorney. It is very important because there's a lot of complicated calculations to determine what the accurate benefits are. If you have any questions or concerns, my office is standing by. Feel free to give us a call. Thank you.